Welcome back to Quick Bits. A lot happened this week, not just in the Rust case for Alec Baldwin, new motions from Hannah Gutierrez's lawyer, which we were expecting, but also a lot happened in the Karen Read case ahead of a hearing scheduled to take place Monday, July 22nd. I'll be covering that live on my live stream channel. Plus, there's a lot happening in the Young Thug case, in the Scandoval lawsuits, and more. So let's break it down in the Quick Bits. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. First, a case out of Idaho that we have been following since it was filed, and that is the defamation case between a University of Idaho professor and a purported TikTok psychic, because the videos at issue in this defamation suit were posted on TikTok. The TikToker is representing herself. The university professor has the same attorney, Wendy Olson, that represented the Media Coalition in the Brian Kohberger criminal prosecution. That case recently went to summary judgment, and the court granted a partial summary judgment, finding the TikToker liable for defamation. That means the case is only going to move forward on the grounds of damages. Well, that is not sitting well with the TikTok psychic, who has made motions for the judge to be removed twice, for the entire case to be relitigated, and for the judge to reconsider the motion. Those are not going to meet any level of success, and this case will keep moving forward towards a damages phase. And if that goes to trial, it's going to go to trial in federal court, which is not televised, but I am going to keep an eye on what happens in this case. It seems that it is a long way from done. Other cases getting ready to go to trial in federal court. The federal criminal case against disgraced attorney Tom Girardi is going to be starting in early August in federal court in Los Angeles. His last bid to have the case put out into November has been denied. So that case is going to be going to trial quickly. Again, no cameras in the courtroom in federal court, but we will see about covering that case. Let me know your level of interest in my take as Tom Girardi goes to criminal trial for the theft from his clients. And we're now seeing that evidence about money given from the Girardi Keese law firm to Erica Girardi's businesses will be allowed in this trial. So it's going to get very interesting. Sticking with reality television, there are more lawsuits in the world of Vanderpump Rules and Scandoval. I broke down the recent filings in the lawsuit where Rachel, who was having an affair with Tom Sandoval behind Ariana Madix, Tom Sandoval's partner's back, filed a lawsuit against Tom and Ariana for distribution of illicit images of her that she says Tom Sandoval recorded without her consent, and that Ariana sent at a minimum from Tom Sandoval's phone to hers and from hers to Rachel's. So that lawsuit is ongoing. Ariana had filed an anti-slap motion and it was denied by the court. Tom Sandoval filed a response and a cross-complaint that has garnered much attention. But in the response to the anti-slap motion, Rachel also filed an extensive affidavit going through, again, her side of what went down in this case. And it lined out that a lot of her concern in this case was, yes, distress over Tom Sandoval's purported recording of a intimate FaceTime video that she did not know was being recorded, but it seemed that her larger distress based on this affidavit was based on Ariana's possession of that video and sending that video to her and not knowing where else that video could or would be sent. Ariana has said repeatedly that the video was sent to Rachel and then Tom deleted it off of Ariana's phone, and it was not sent or shown to anyone else and was not in her possession except briefly when she sent it to Rachel, which seemed to be the first time Rachel became aware that Tom had been recording those FaceTime calls. So Tom Sandoval filed a cross-complaint against Ariana within the Rachel lawsuit, asking the court for declaratory relief that if he is responsible for any damages, Ariana should be responsible for his portion because it was her entry into his phone that caused the substantial amount of damages. This caused a media whirlwind. Tom Sandoval recently released a statement on Instagram. His statement is, late Tuesday afternoon, my attorney Matt Garagos, yes, Matt Garagos is the brother of Rachel's lawyer, Mark Garagos. Matt Garagos, whose advice I trusted, called me about the cross-complaint in the lawsuit against myself and Ariana. This was filed Wednesday. I can't believe an attorney would spend billable hours drafting this without previously having a conversation with a client about it. But he continues. He assured me that the action was customary and strictly preventative in these types of lawsuits and urged me to agree to it. The words, quote, new lawsuit or suing were never articulated to me. Well, it is a cross-complaint for declaratory relief, but you are bringing an action against her. It is not a new lawsuit. It is a lawsuit within a lawsuit. So, of course, your lawyer would never say new lawsuit because it's a cross-complaint. The media doesn't always see it that way, and all of this should have been discussed beyond just with Tom and the lawyer, and I wonder if it in fact was, and he just didn't think people would be that mad. He goes on to say, I should have done my due diligence on the matter, okay? Upon realizing what this action actually means, I have removed Matt Garagos from my legal team. In no way am I suing Ariana. I mean, you are, though. That's what the action is. The action against Ariana brought on my behalf is being removed. I will keep you up to date when I see that reflected in the court records. He goes on to say, I hold no ill will or vindictiveness towards Ariana. Now, by removing both the cross-complaint and the attorney who recommended it, I hope to get through this case quickly so that Ariana and I can both finally move on with our lives. When I see the filings in court, I will let you know, and I am sure Ariana is ready to move on, but she is facing another lawsuit. We have not broken this lawsuit down yet, but will in the future when a time allows. But Chef Penny, the former purported business partner of Ariana and Katie in opening the sandwich shop, Something About Her, has sued to more thoroughly define that partnership agreement, saying that she has not been paid under the partnership agreement in the ways that the parties agreed. And we will go over that more thoroughly at another time. So you're gonna have to let me know how interested you are in covering that in light of everything else we've got going on. Speaking of everything else, the now 18-month-long Young Thug RICO trial out of Georgia finally has a third judge. This week on the Emily Show podcast, available on your audio feeds and over on the Emily D. Baker YouTube channel, I broke down Judge Glanville's recusal from the case. The motion for recusal and motion for dismissals were filed by numerous lawyers in the case. There are 6 defendants currently in trial in a 28-defendant indictment, but the judge who heard that motion did recuse Judge Glanville based on his actions in handling the recusal motions, not because of the ex parte hearing with the prosecution, with a prosecution witness and that witness's attorney. And the judge made it very clear to parse out that the recusal was over the way those motions were handled, because once the recusal motion is filed, the judge shall not defend and shall means must, shall assign that motion to another judge. Judge Glanville did not do either of those things, and for that reason was recused from the case. A second judge was assigned to the case, and that judge within 2 days recused themselves due to an issue with their former court deputy. Their former court deputy was the deputy arrested in this case for having an inappropriate relationship with one of the defendants. That happened very early on in the case, and I covered it in the original podcast where I broke this case down. But yes, one of the deputies had been arrested for actions taken while having that relationship with one of the defendants, including finding alone time while that defendant was in the courthouse, arranging to get things to that defendant while they were in custody, and acting, it seems, as somewhat of a go-between. So with all of that, that judge recused herself and a third judge was appointed. Judge Whitaker held a hearing in the Young Thug case on Friday to lay some new ground rules and give everybody a reset, to indicate that it was her fervent desire that this case move along more quickly. There was no reason this case should be going on as slowly as it has. The judge seems to have indicated that she will be exercising her judicial discretion against cumulative evidence, that she will be strictly enforcing that everyone be ready to start court at 8:45 in the morning, and that there will no longer be eating, snacking, and less formal behavior in court, and that the prosecution is to have their witnesses stacked and ready to go, meaning one witness is done, the next witness takes the stand. This case has already been in evidence for over 6 months. And it looks like the judge has set a date at this time for the jury to come back August 5th. So this case maybe will start moving along in a quicker manner, but there are still a number of motions that are pending. There are still motions for dismissal that need to be addressed. And even though this judge had fundraisers hosted for them by a number of the defense attorneys here, it is not going to be an issue that prevents this judge from moving forward. And cases that are asking for dismissal, we've got to talk about the Hannah Gutierrez Rust Armorer case. After the stunning Baldwin dismissal during trial now 2 weeks ago, Hannah Gutierrez's lawyer immediately made comment that he would be filing a motion to dismiss Hannah Gutierrez's case, and that motion has been filed. It is a motion to dismiss and a motion for new trial. The standard under the law post-trial for the violations alleged by the prosecution is a different standard than what Baldwin's team had to overcome at trial. So there is a different legal standard at play here, and it is a more difficult standard, which is why he is asking for both a new trial and or a dismissal. He's also asking that Hannah Gutierrez immediately be removed from custody pending this motion. In that motion, we learn that the defense is alleging there are over 900 pages of discovery that the prosecution did not turn over to them. Remember, the prosecution's obligation to turn over discovery and Brady discovery is ongoing. That means even after trial, if you find new shit, you have to turn it over. They are also arguing that the prosecution did not turn over critical reports authored by the prosecution's experts that the experts would have been cross-examined on during the trial. What's most interesting in all of this is the prosecutor listed as the responsive prosecutor for all of these motions in the Hannah Gutierrez Reed trial is still Carrie Morrissey. And in fact, the district attorney's office in the 1st District of New Mexico has indeed stated that Carrie Morrissey will stay on this case. So we should be seeing a written opposition from Carrie Morrissey soon. I'm very interested to see how this explanation goes, but the judge is well familiar with what the defense is calling a pattern of behavior of Carrie Morrissey as special prosecutor in this case, and the failure to turn over these reports, because all of it also came up in the Baldwin case. And with regard to the expert report, when Carrie Morrissey made the wild decision to testify in that hearing in the Baldwin case, she admitted that she knew the failure to turn over that report was a Brady violation. So there are ongoing issues here that go well beyond the ammunition that was turned over to the sheriff's department that Hannah Gutierrez's defense team was aware of. So that is not the only grounds here. There is so much more. And that is going to come to hearing likely very quickly. So if you're interested in following along with the fallout in the Rust case, make sure you download the Law Nerd app at lawnerd.com so I can keep you in the loop, not just when the Quick Bits episode drops, but also when I am going live. And if there are new filings, when I am addressing those in the middle of an ongoing live stream, which is exactly what happened last week with the Karen Reed case. Last week in the Karen Reed case, both days that I was streaming, new filings dropped, and we were able to send out app notifications to be like, breaking news. We're covering it, and I don't cover breaking world news, but when there is new stuff going on filed in court in the cases I'm covering, I will interrupt a live stream or extend it to cover those new filings. And there is a lot going on in the Karen Reed case. There has now been a defense motion to dismiss with multiple amendments, the Commonwealth's opposition to that, the defense's reply to that, and a juror made a motion directly to the court. That entire motion is also on the Quick Bits channel if you just want to see what the juror had to say about this case. Interestingly enough, the juror was silent in that affidavit about any voting on the case and simply said that the jury was unable to come to a unanimous verdict, which is squarely different than what we're seeing in the defense motions to dismiss, where they say that numerous jurors, 5 now, have come forward and in some way stated that they reached unanimous verdicts on counts 1 and counts 3. Those are the second-degree murder count and the leaving the scene of an accident causing death count. Those 2 counts did not have lesser included charges. Count 2 is the count for the driving under the influence causing death, and that is the count that had the lesser included charges. So the defense's argument is that the jury did come to verdicts on counts 1 and 3, and therefore the prosecution cannot go forward and retry Karen Read on counts 1 and 3. In support of that motion, the defense has filed multiple affidavits. 3 jurors have spoken directly to attorney Alan Jackson, all 3 indicating the same thing. 2 other jurors spoke to individuals in their circle, in their life, and those individuals told a friend who told the defense attorneys. So as to those other 2 jurors, it is a game of telephone with multiple parts. But as to the 3 jurors that spoke to Alan Jackson, it might be enough that the court allows for the attorneys to either inquire further, allows for affidavits to be gathered from the jurors, or allows for the jurors to be asked in a very narrow way, did they in fact come to verdicts on count 1 and 3? Now, those verdicts can't be entered at this point. That jury has been dismissed. Their jury duty is over. And inquiring about their result might be something the judge is very hesitant to do. Minds can change after deliberations, and reopening deliberations cannot legally be done. But the defense is arguing if the jurors did in fact come to a result, then Karen Read is being put in jeopardy again if retried, and that violates the double jeopardy clause of both the state and federal constitutions. So the defense is saying, Your Honor, you must dismiss these charges. It is going to be a difficult legal battle for the defense because not all of the case law is on their side. In fact, most of it is not. However, it does seem there is a path for them to at least ask the jurors if they reached a result. Again, a lot of the case law is not on their side in this, and the smoothest way forward, of course, would be for the prosecution, if convinced that the jurors did in fact reach verdicts, to dismiss those charges on their own. But based on their animate opposition to the defense's motion, it seems unlikely that the prosecution will choose to dismiss counts 1 and 3 and choose to just retry Karen Read on count 2. But this is a long way from done, and I do not expect any result at the hearing on Monday. Even if there is a ruling from the judge, this is likely all going to be appealed by the defense if the judge rules against them, and I imagine they will use that as grounds to put off any new trial for some time into the future, saying that the appellate court needs to decide whether or not she would be twice put in jeopardy, because once you start a retrial, then her rights have already been violated. So even though a swift resolution is, I think, what many would like to see, it's unlikely in this case that anything will get resolved quickly. We have talked about a lot of shit in this quick bits, but we're going to take a minute to talk about it just a little bit more and talk about why over 2 million butts love Tushy. Look, I had never considered a bidet. I didn't even know that you could get one that just installed in like under 10 minutes and just went on your toilet seat and just transformed your current toilet. I thought you had to go like all DJ Khaled and like get some $5,000 toilet and have like a special technician install it into your house, but you don't. I really wish I had had this during my spinal fusion. I will spare you from all of the details when things can be a bit more challenging to take care of. If you have ever dealt with physical limitations that make it hard to take care of the do, Tushy might be an amazing solution for you. Look, it doesn't matter what it is. Bad shoulders, bad back, super long fingernails, whatever it is, the Tushy can help keep you clean. So if you're ready to stay shower fresh all summer long, now is the time to join the 2 million butts who already love Tushy. For a limited time, our listeners get 10% off their first bidet purchase when you use code LAWNERD at checkout. Don't forget to do that with all caps, okay? That's 10% off your first order at hellotushy.com and use promo code LAWNERD. Now let's get back to the rest of the shit on today's episode, which is incredibly unfortunate given that juror affidavit that they are deeply concerned that if the juror list is made public, that they would be subject to threats and harassment because the jurors have seen what is going on across social media and locally in this case. The jurors cited specifically how uncomfortable they were seeing on social media the way that people were attacking the sitting judge in this case. So it is always a good opportunity for a reminder that going real world with people is absolute bullshit, that jurors do a civic duty that they are called to do. They don't choose jury duty. Jury duty drafts them out of their lives, and in this case, for 9+ weeks. So these jurors left their jobs for over 9 weeks to sit in that courtroom and try to decide a result. Their deep concerns over being harassed, threatened, confronted, or physically harmed is unfortunately incredibly valid in this case, based on how heated online and offline confrontations about this case have gotten. But it's not on the jurors. They are doing their civic duty. The judge sealed the jury list indefinitely. In Massachusetts, they call it impoundment. So if you see headlines talking about the judge impounding the jury list, that's what it means. It is sealed. The jury list will not be accessible to any members of the public or media in any way until there is a further order. That does not limit jurors from choosing to come forward. They are welcome to do so. But given that affidavit, I doubt any will. And the link to that entire motion clipped out of the almost 6-hour live stream is going to be linked down below so you can listen to what that juror had to say in their affidavit if you like. And with how much has gone on this week, I feel like the quick bits aren't even quick anymore, but thank you for being here. Thank you for being a Law Nerd. It's always good to see you. And I will see you back in live court on Monday. And there are more hearings happening this week. We'll be updating the docket. And if you are a member over on the YouTube channel, don't forget to go check out our last Members Only Live. It was a long one, but if you want to know all about my trip to New Kids on the Block, then you're going to have to go over and listen. And I will talk to you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.